At Micro Focus, we've taken a particular interest in personal data protection really on a global basis. In Europe, we have something called the General Data Protection Regulation of 2016, which, if you like, compares with the Privacy Act here in Australia of 1988 and its subsequent amendments. And the real question for us as Micro Focus, as a software solution provider, is to what extent does this apply to Australian organizations that are dealing with the personal data of European citizens? There are also two other reasons where we should be examining issues. First of all, are there lessons we can learn from Europe with this regulation that is being applied by the 25th of May of this year? And can we apply those also to Australian entities with their own national legislation? There's also a third and really quite unusual aspect that we've discovered, which is to do with the fact that as a result of dealing with compliance, there can actually be some bigger strategic objectives of how rules are applied across an organization. In terms of the aspects of data protection, I'd suggest that looking at both the Australian and the European standards, they're relatively similar. There are some significant differences. For example, in Europe, we have something called the right to be forgotten, that within 28 days you must find my information and remove it. There is no such concept here in Australian law, but there's something which is relatively similar, and that is called purpose limitation. What that means to say is if I have given consent for a certain time or for a certain purpose, and that purpose or that time finishes and elapses, then that information must be found. The significant point here is it's turned something from being a passive obligation, so to speak, I could just put data in a data lake, into something which is now an active requirement for organizations to go and find data and to delete it. So that's one aspect. The second aspect, I suppose, in terms of high profile, will be to do with the sanctions. Under the GDPR in Europe, that sanction is 4% or maximums of 4% of your annual turnover, or 20 million euros, whichever the higher. Here, under the Australian Privacy Act of 88, it is 2.3 million Australian dollars. So if you like, a different magnitude of financial issue. But for us, there are much more significant aspects here. One is to do with reputational damage. It's one thing, for example, losing information, as in the case of the Red Cross a few years back in terms of blood donor information. So the impact is not really a question of the fine, but there's a key word here for me, and that is trust. Can I trust you with the personal information that I have? Something that we found unusually, just from listening to our clients in Europe over the last 2 years, has been that, if you like, compliance with the regulation isn't simply a matter of further enforcement within the organization, further clamping down on how one may act. There are surprisingly, coming from our clients, a whole number of different benefits. Let me give you some examples. So operational efficiency. Take that example I gave earlier, which is to do with the right to be forgotten under GDPR, that within 28 days you must find my information. For large corporations, especially those who are dealing with personal and sensitive information, like insurance and in banking, this is a tough ask. Why? Because of the variety and type of data that is involved, because we're no longer just simply talking about emails or contracts or Word documents. We're now in the domain of things like social media, audio, visual, and alphanumeric. Only last week, I was looking at an advertisement from a bank in Singapore, which is talking about voice banking, which is not only dealing with voice communication, but also facial recognition. So actually, for chief information officers, this is an opportunity not only to handle and make sure one is compliant, but also to realize that the reason why it's difficult is because of the sheer volume of what we call dark data existing. In Europe, almost 30% of the data in many large corporations is what we call dark data, redundant, obsolete, or trivial. So this is the real opportunity and time for a CIO to go and find this data and to delete it, and thereby enable the organization to fulfill their obligations, and at the same time, to achieve a return on investment. So here in Australia, from the 22nd of February of this year, you now have this mandatory notification of a data breach. What that's doing is highlighting the issue of cybersecurity in general. And even the Prudential Regulatory Authority here in Australia, even just today, was saying they believe that a serious cyber breach could actually bring down a whole corporation. So those are the, if you like, the tough issues, and especially the point that no organization can say it is completely cyber attack defensive and proven. But there is a certain upside to this, and that is in relation to insurance. There are major insurers who are providing the opportunity to insure against a cyber attack. But they will only do that on the basis that you have done everything reasonable and positive to protect yourself. So what we're finding is that insurers are asking clients, please go and get a consultancy to check out your security standards in terms of cyber defense, so meaning not only the external piece, but also the internal encryption of data, penetration testing, and on the basis of this, if it's appropriate and sufficient, we will actually reduce your premiums. So here we have a financial saving as a result of being prudent and cognizant of the data protection issues. So we've discussed the issue in relation to pure compliance, making sure that one does not have a reputational hit and avoids fines. But we've also talked about the upside of operational efficiency, and there's even a third aspect which we should consider, and really coming from our clients' commentary. And that is to do with actually really generating new revenue as a result of compliance. Now this sounds contradictory. How can you make money out of being compliant? Well, a very simple concept is that increasingly around Europe, if you want a new product or service and you ask that provider, so how good are you at what you're doing? What is one of your other due diligence questions going to be? Can I trust you with my data? Are you GDPR effective? Are you Personal Data Act 1988 here in Australia effective? Because if you're not, you're going to lose my business. Turn that round the other way, listening to a media company, for example, in the Nordics, for them to be able to say GDPR effective on the website as a way of improving brand loyalty of existing customers and attracting new ones. So the idea that being compliant is actually helping your primary revenue is a really exciting one.